Thank you for visiting the Miltenberger Law Offices YouTube channel and our website. We are a proven criminal defense law firm in Nebraska with over 1,000 cases handled and over 12 years of combined legal experience. Our firm has created these audio articles to help educate you on your rights, protect your freedom, and help you achieve the best solution for the charges you are facing. If we are hired for your case, we will never back down, no matter the odds. Possession with intent to distribute. Lawyer in Omaha, Nebraska. A drug possession with intent to distribute charge in Omaha is not simple possession. Sometimes prosecutors take the position that the drugs were not intended for personal use at all. Instead, they allege the substances were intended for sale, distribution, delivery, or transfer to another person. That distinction matters a lot. Possession with intent to distribute, also known as PWID, charges often carry significantly more severe penalties than simple drug possession offenses in Omaha and can expose individuals to lengthy prison sentences, substantial fines, and life-changing collateral consequences. At Miltenberger Law Offices, we represent clients facing possession with intent to distribute allegations throughout Omaha, Douglas County, and across Nebraska. Whether the case involves marijuana, methamphetamine, fentanyl, cocaine, heroin, prescription medications, or another controlled substance, our goal remains the same: protect your rights, challenge the government's evidence, and pursue the best possible outcome. If you've been arrested, charged, or believe you're under investigation for possession with intent to distribute in Omaha, call 402-217-2267 or contact us online to speak with an experienced Nebraska drug crimes defense attorney. Because possessing drugs and intending to distribute drugs are two very different allegations, unfortunately, prosecutors sometimes treat one as proof of the other. What is possession with intent to distribute in Nebraska? Under Nebraska Revised Statute, Section 28-416, it is unlawful to manufacture, distribute, deliver, dispense, or possess certain controlled substances with the intent to distribute them. Unlike a simple possession charge, prosecutors must prove more than the fact that drugs were present. They must also convince a judge or jury that the accused intended to distribute those drugs to someone else. That sounds straightforward. It usually isn't. Intent cannot be photographed. It cannot be collected in an evidence bag. It cannot be dusted for fingerprints. Instead, prosecutors often attempt to prove intent through circumstantial evidence and assumptions about what certain items supposedly mean. That creates opportunities for a strong defense by an Omaha PWID defense attorney. How prosecutors try to prove intent to distribute. In many Omaha possession with intent to distribute cases, there is no video showing a drug sale and no direct evidence proving that drugs were transferred to another person. Instead, prosecutors frequently rely on circumstantial evidence such as drug quantity, packaging materials, cash, scales, multiple containers, cell phone communications, text messages, social media messages, alleged customer lists or ledgers, statements from informants, controlled purchases. Interestingly, none of those things automatically proves distribution. A large quantity of drugs may raise questions, so might cash, or scales, or text messages. But suspicion and proof are not the same thing. The government still bears the burden of proving intent beyond a reasonable doubt. Common possession with intent to distribute charges in Omaha. Miltenberger Law represents clients facing a wide range of distribution-related drug allegations throughout the Omaha area and across Nebraska, including marijuana possession with intent to distribute. While some marijuana cases involve personal use allegations, others involve accusations that the marijuana was intended for sale or transfer. Prosecutors often focus on the amount involved, packaging materials, cash, and electronic communications when pursuing these cases. However, possessing a larger quantity does not automatically establish intent to distribute. Methamphetamine possession with intent to distribute. Methamphetamine offenses are aggressively prosecuted throughout Nebraska. Law enforcement agencies frequently dedicate substantial resources to meth-related investigations, often involving surveillance, search warrants, confidential informants, and multi-agency cooperation. As a result, methamphetamine distribution allegations often carry significant legal exposure. Fentanyl possession with intent to distribute. According to the Centers for Disease Control and Prevention and the DEA, fentanyl continues to play a major role in overdose deaths throughout the United States. Because of the heightened attention surrounding fentanyl, prosecutors often pursue these distribution cases aggressively. These allegations alone can carry severe penalties and often involve complex forensic and evidentiary issues. Cocaine possession with intent to distribute. Cocaine-related distribution cases often involve allegations stemming from vehicle searches, traffic stops, search warrants, and ongoing investigations. Prosecutors frequently attempt to use quantity, packaging, communications, and financial evidence to support allegations of intent. Heroin possession with intent to distribute. Heroin distribution allegations remain among the most serious drug offenses prosecuted in Nebraska. Depending on the facts of the case, these investigations may involve state agencies, federal agencies, or both. Prescription drug distribution cases. Not every Omaha possession with intent to distribute case involves street drugs. Many involve prescription medications, including Adderall, Xanax, oxycodone, hydrocodone, morphine, other controlled prescription medications. These cases often involve allegations that medications were shared, sold, transferred, or possessed for purposes beyond lawful medical use. Drug quantity doesn't automatically equal intent. One of the most common misconceptions in drug cases is that possessing a certain amount automatically proves an intent to distribute. That's not how the legal system works. Prosecutors may argue that larger quantities suggest distribution. They may point to packaging materials or cash found nearby, but quantity alone does not necessarily answer the question of intent. A large amount of drugs may raise suspicions. It does not automatically resolve them. The government still has to prove what a person intended to do. And that's often where these cases become much more complicated than prosecutors would prefer. Possession with intent to distribute resources in Omaha, Nebraska. Legal Information Institute Overview of Search and Seizure Law. This resource explains the legal principles governing searches, warrants, probable cause, consent searches, and the exclusion of unlawfully obtained evidence. Many drug possession cases in Omaha rise or fall based on whether law enforcement followed constitutional requirements when gathering evidence. National Institute on Drug Abuse, NIDE. Part of the National Institutes of Health, NIDA conducts research on drug use, addiction, treatment, and public health trends. The organization provides extensive information regarding commonly abused substances, opioid-related issues, and the science behind addiction and recovery. Nebraska Possession with Intent to Distribute Laws Online Database, the Nebraska Legislature's online version of the state's primary controlled substances statute. This law outlines many Nebraska drug offenses, including possession, distribution, manufacturing, and related crimes, along with the classifications and penalties that may apply. Law Enforcement Action Partnership, Statens LEAP, a national nonprofit organization composed primarily of current and former law enforcement professionals, prosecutors, judges, and other criminal justice experts. LEAP advocates for evidence-based criminal justice and drug policy reforms while providing educational resources on public safety, community relations, and the impact of drug laws throughout the United States. How much more serious is possession with intent to distribute in Omaha? One reason prosecutors pursue possession with intent to distribute charges so aggressively is that the potential penalties can increase dramatically compared to simple possession offenses. The following table illustrates how Nebraska law treats certain possession and possession with intent to distribute allegations. While every case is different, the comparison makes one thing clear. When prosecutors add allegations of distribution, the stakes increase quickly. Difference in penalties for drug possession and possession with intent to distribute in Nebraska. Methamphetamine, also known as meth or speed, Schedule 2, C, 3, 4. Quantity, any detectable amount up to 10 grams. Penalty for simple possession, up to 2 years imprisonment and 12 months post-release supervision, or $10,000 fine, or both. Class 4 felony. Penalty for manufacture/delivery/dispensing/PWID, not less than 1 year and not more than 50 years imprisonment. Class 2 felony. Quantity, at least 10 grams less than 28 grams. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 3 years and not more than 50 years. Class 1 D felony. Quantity, at least 28 grams less than 140 grams. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 5 years and not more than 50 years. Class 1 C felony. Quantity, 140 grams or more. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 20 years and not more than life. Class 1 B felony. Heroin, Schedule 1 B 11. Quantity, any detectable amount up to 10 grams. Penalty for simple possession, up to 2 years imprisonment and 12 months post-release supervision, or $10,000 fine, or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 1 year and not more than 50 years. Class 2 felony. Quantity, at least 10 grams less than 28 grams. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 3 years and not more than 50 years. Class 1 D felony. Quantity, at least 28 grams less than 140 grams. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 5 years and not more than 50 years. Class 1 C felony. Quantity, 140 grams or more. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 20 years and not more than life. Class 1 B felony. Cocaine or base cocaine, also known as crack. Schedule 2, A4. Quantity: any detectable amount up to 10 grams. Penalty for simple possession: up to 2 years imprisonment and 12 months post-release supervision or $10,000 fine or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 1 year and not more than 50 years. Class 2 felony. Quantity: at least 10 grams less than 28 grams. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 3 years and not more than 50 years. Class 1 D felony. Quantity: at least 28 grams less than 140 grams. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 5 years and not more than 50 years. Class 1 C felony. Quantity: 140 grams or more. Simple possession penalties not applicable. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 20 years and not more than life. Class 1 B felony. Phencyclidine, PCP, Schedule 2 D4. Quantity: any detectable amount. Penalty for simple possession: up to 2 years imprisonment and 12 months post-release supervision, or $10,000 fine or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 1 year and not more than 50 years. Class 2 felony. Lysergic acid diethylamide, LSD, Schedule 1 C7. Quantity: any detectable amount. Penalty for simple possession: up to 2 years imprisonment and 12 months post-release supervision, or $10,000 fine or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, up to 20 years imprisonment. Class 2 a felony. Fentanyl, also known as China White. Schedule 2 B5. Quantity: any detectable amount. Penalty for simple possession: up to 2 years imprisonment and 12 months post-release supervision or $10,000 fine or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 1 year and not more than 50 years. Class 2 felony. Exceptionally hazardous drugs, defined at Section 28-401-29-5. Quantity: any detectable amount. Penalty for simple possession: up to 2 years imprisonment and 12 months post-release supervision or $10,000 fine or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, not less than 1 year and not more than 50 years. Class 2 felony. Schedule 1/2/3, not exceptionally hazardous. Quantity: any detectable amount. Penalty for simple possession: up to 2 years imprisonment and 12 months post-release supervision or $10,000 fine or both. Class 4 felony. Penalty for manufacture/distribution/delivery/dispensing/PWID, up to 20 years imprisonment. Class 2 a felony. Schedule 4 or 5 substances. Quantity, any detectable amount. Penalty for simple. Possession, up to 2 years imprisonment and 12 months post-release supervision or $10,000 fine or both. Class 4 felony. Penalty for manufacture/delivery/delivery/dispensing/PWID. Up to 3 years imprisonment and 18 months post-release supervision or $10,000 or both. Class 3A felony. State charges versus federal drug distribution cases. Some possession with intent to distribute cases remain in Nebraska state court. Others move into the federal system. Federal prosecutors may become involved when allegations include interstate transportation, drug trafficking investigations, large quantities of controlled substances, conspiracy allegations, wiretap investigations, multi-state operations, DEA involvement. Federal court is not simply state court with a larger building. The rules, procedures, sentencing guidelines, and resources available to federal prosecutors can be dramatically different. It's generally not the place where you want to see how things go. Many distribution cases in Omaha begin with a search. One of the most important issues in many possession with intent to distribute cases involves how law enforcement obtained the evidence. Many investigations begin with traffic stops, vehicle searches, search warrants, home searches, cell phone searches, surveillance operations, confidential informants. The Fourth Amendment protects individuals from unreasonable searches and seizures. Courts have spent decades defining when officers may stop vehicles, search property, obtain warrants, and seize evidence. In some cases, the strongest defense is not whether drugs were found. It's whether law enforcement had the legal right to find them in the first place. Common defenses to possession with intent to distribute charges. Every case is unique, but certain defenses frequently arise in Nebraska distribution cases. Illegal search and seizure. Evidence obtained in violation of constitutional protections may be challenged and potentially excluded from court. Lack of possession. Prosecutors must establish that the accused actually possess the controlled substance. In shared vehicles, residences, and common spaces, that issue is not always straightforward. Lack of intent. Possession and distribution are different allegations. Even if prosecutors can prove possession, they still must prove intent to distribute. Problems with informant testimony. Many distribution investigations rely heavily on confidential informants and cooperating witnesses. These individuals may have personal motives, pending charges, or incentives to provide information favorable to law enforcement. Problems with digital evidence. Text messages, social media communications, and cell phone records are frequently used in distribution cases. Context often matters far more than prosecutors suggest. Laboratory testing issues. The government must establish that the alleged substance is actually a controlled substance. Mistakes in testing, documentation, and evidence handling can create important defense opportunities. Insufficient evidence. The burden remains entirely on the government. You do not have to prove your innocence. Prosecutors must prove every element of the offense beyond a reasonable doubt. That's a much higher standard than many people realize. What should you do if you're charged with possession, with intent to distribute in Omaha? Being charged with possession with intent to distribute is not something you want to handle casually. Prosecutors are alleging more than simple possession. They're claiming you intended to distribute controlled substances to other people. What you do next can have a major impact on your case. Our PWID defense attorneys in Omaha suggest you follow these steps. Step 1. Exercise your right to remain silent. This is one of the most important decisions you can make. Law enforcement officers are trained to gather information, and many people unintentionally damage their cases by trying to explain what happened. You have the right to remain silent. You have the right to an attorney. Use both. Politely provide identifying information if required, but avoid answering questions about the allegations until you've spoken with counsel. Step 2. Do not consent to additional searches. If officers ask for permission to search your vehicle, home, phone, computer, social media accounts, or personal belongings, you generally have the right to decline consent. Refusing consent does not make you look guilty. It preserves your rights. If law enforcement has a warrant or another legal basis to conduct the search, they may proceed regardless. However, there is rarely a benefit to volunteering additional access. Step 3. Contact a possession with intent to distribute lawyer immediately. Time matters in these cases. The earlier an Omaha PWID attorney becomes involved, the more opportunities there may be to preserve evidence, protect constitutional rights, challenge searches and seizures, communicate with investigators, review warrants and affidavits, identify weaknesses in the government's case, begin developing a defense strategy. In some situations, legal intervention may occur before formal charges are even filed. Step 4. Preserve potentially important evidence. Many Omaha distribution investigations involve digital evidence. Save anything that may be relevant, including text messages, emails, call logs, photos, videos, social media communications, receipts, GPS or location information, financial records. Do not delete anything. Even information that seems unhelpful may ultimately provide valuable context for your defense. Step 5. Stay off social media. This advice is remarkably simple. Do not post about your case. Not on Facebook, not on Instagram, not on TikTok, not on Snapchat, not anywhere. Prosecutors and investigators routinely review social media activity during criminal investigations. Posts, comments, photos, videos, and private messages can all become evidence. If you wouldn't want a prosecutor displaying it on a large screen in court, don't post it. Step 6. Follow all release conditions. If you've been released from custody, carefully comply with every condition imposed by the court. This may include appearing for court hearings, drug testing requirements, travel restrictions, no contact orders, pretrial supervision requirements, probation-related conditions. Violating release conditions can create additional legal issues and complicate an already serious situation. Step 7. Be completely honest with your attorney. Your attorney's job is to help you. That becomes much easier when they have accurate information. Attorney-client communications are confidential, allowing you to speak openly about the facts of your case. Surprises are wonderful when someone brings cake. They are considerably less enjoyable during felony drug proceedings. The more information your defense attorney has, the better prepared they can be to identify risks, anticipate arguments, and build the strongest defense possible. Frequently asked questions about possession, with intent to distribute charges in Omaha. What's the difference between simple possession and possession with intent to distribute? Answer: simple drug possession in Omaha generally involves allegations that drugs were possessed for personal use. Possession with intent to distribute involves allegations that the drugs were intended for sale, delivery, transfer, or distribution to another person. The penalties are often significantly more severe. Can I be charged with intent to distribute in Omaha, even if no drugs were sold? Answer: yes. Prosecutors do not necessarily need evidence of a completed sale. Instead, they often rely on circumstantial evidence such as quantity, packaging materials, cash, communications, or other factors they believe suggest an intent to distribute. Does having a large quantity of drugs automatically prove intent to distribute in Nebraska? Answer: no. While prosecutors frequently use quantity as evidence of intent, quantity alone does not automatically establish what a person intended to do. The government must still prove every element of the offense beyond a reasonable doubt. Can text messages be used as evidence? Answer: yes. Prosecutors often rely on text messages, social media communications, call records, and other digital evidence in possession with intent to distribute cases. However, context matters, and communications do not always mean what investigators claim they mean. What if the drugs weren't mine? That may be an important defense. Prosecutors must prove possession as well as intent. In cases involving shared vehicles, residences, hotel rooms, or common spaces, ownership and control are often heavily disputed. Can possession with intent to distribute charges be reduced in Omaha? Answer: every case is different. Depending on the facts, the evidence, and the legal issues involved, charges may be challenged, reduced, dismissed, or resolved through negotiated outcomes. Will my case be handled in federal court? Answer: not necessarily. Many cases remain in Nebraska State Court. However, allegations involving interstate activity, larger investigations, conspiracy claims, or federal agencies may result in federal prosecution. When should I contact a lawyer? Answer: immediately. The sooner an Omaha PWID defense attorney becomes involved, the sooner steps can be taken to preserve evidence, protect your rights, evaluate the government's allegations, and begin building a defense. Why choose Miltenberger Law Offices? Possession with intent to distribute cases are often built on assumptions. Assumptions about why drugs were present. Assumptions about what text messages mean. Assumptions about why cash was found. Assumptions about what someone intended to do. At Miltenberger Law Offices, we carefully examine the evidence, the investigation, and the government's conclusions to determine whether those assumptions actually hold up under scrutiny. We evaluate search warrants, traffic stops, digital evidence, witness statements, laboratory testing, and every other aspect of the case to identify weaknesses and opportunities for defense. Because serious criminal charges deserve more than assumptions. They deserve scrutiny, and they deserve a defense. Talk to an Omaha possession with intent to distribute lawyer today. If you've been arrested, charged, or believe you're under investigation for possession with intent to distribute in Omaha, Douglas County, or elsewhere in Nebraska, now is the time to act. The earlier an attorney becomes involved, the more opportunities there may be to protect your rights, preserve evidence, challenge the government's case, and begin building your defense. Call 402-217-2267 or contact Miltenberger Law Offices online today to discuss your situation confidentially and learn how an experienced Omaha possession with intent to distribute lawyer can help. Because allegations are not convictions and assumptions are not proof. Miltenberger Law Offices is a leading criminal defense law firm serving the entire state of Nebraska. We are headquartered in Omaha and serve Douglas County, Lancaster County, Lincoln, Sarpy County, and all of Nebraska. We look forward to helping you with your criminal defense attorney needs.